Welcome back to the Golf Unfiltered podcast. Hello to everyone in YouTube land. That is Will Bardwell. Will, you're basically the resident legal expert for all of golf Twitter now, I think.
That is a sad statement about the services that golf Twitter has available to it. But as with anything else, in legal services, you get what you pay for. So
Fair enough. Well, the reason that I had you on, thank you so much for doing this. Earlier this week, obviously the big news in pro golf, at least, is the lawsuit that was filed by 11 former PGA Tour players against the PGA Tour. You wrote an excellent piece on your lying4.com website, aptly entitled, "And Here We Go," where you kind of break down the finer points of the lawsuit for the layman. And I think to discuss this particular topic, obviously you being the expert in terms of the legalese and many other things, it all begins, and let me know if I have this right, it begins with what we saw earlier this week, which was filing a complaint. And so maybe start with, what does that even mean?
So a complaint is just a document that you use to start a lawsuit. That's all that is. In the old days, you hear people talk about filing a complaint or filing a motion. In the old days, you would literally, you would type up your document, you would type up your complaint, which just has, it names who the plaintiffs are, who the defendants are, what you say they did wrong, what legal rights they violated, and what you want. You would type that up, sign it. You would walk it down to the courthouse, and you would hand it to the clerk, and they would literally pull out a file folder and stick your document in there, and that would be your file. And every time you had something new to file, they would, same thing. You would walk it down there, you would hand it to them, they would stick it in your file, and whenever the judge wanted to, make rulings in your case or needed to look at something, they would go pull your file, and it was a literal file folder. We still use that word today, although of course it's not done like that anymore. It's all done electronically. But anytime you hear somebody say file, that's all that means. So when you file a complaint, that is just a short, simple statement of what the case is about, and that is the document that starts a lawsuit.
Got it. And in your piece that you wrote on lying4.com, you mentioned the length of this particular document was of note, being 105 pages.
Yeah, well, I used the phrase short, simple statement a minute ago. That is not a phrase that I made up. That's the phrase that the Federal Rules of Civil Procedure uses in terms of what your complaint is required to be. It doesn't have to be anything fancy. It's not unusual to see perfectly valid complaints that are 4 or 5 pages long. The fact that this one is 105 pages doesn't mean that it's any better or worse than a complaint that is more typical, but when you see a complaint this long, it generally means that the plaintiff's attorneys are trying to send a message early on that there's a lot to talk about in this case.
So in this case, what the 11 players, headed by names such as Phil Mickelson, of course, Bryson DeChambeau, others, what they are alleging, is it even appropriate to say that there's something is being alleged right now?
Yeah, and in fact, that is exactly the word, because a complaint is not evidence. It's just one side's version of the story. And so the entire complaint at this point, all it is allegations that have not yet been proven. And, from the tour standpoint, might never be proven. But there's no evidence in the case yet. These are just purely allegations.
Okay, and so what is being alleged right now, and I'm just going to try to summarize, and please help me fill in the gaps, is it's an antitrust. It's going in that direction, essentially, where they are accusing the PGA Tour of monopolistic, anti-competitive behavior.
Correct. There are 2 claims under the Sherman Act, which is a federal law that prohibits certain antitrust violations. There is also a claim under the California equivalent of the Sherman Act. But the gist of the argument is that the PGA Tour has misused its monopoly position in an anti-competitive way. And you've heard a lot of people who've been skeptical of this lawsuit say things, what are they expected to do? That LIV is the other side. Of course, they're supposed to fight back. Well, there's a fundamental difference between out-competing the other side and being anti-competitive. If you and I own hamburger restaurants across the street from each other, and your hamburgers taste better than mine, they're cheaper than mine, your restaurant is cleaner than mine, you've got better outdoor seating, you've got better beer specials, then I'm going to go out of business. And it's not because you misused your monopoly authority. It's just you outcompeted me.
Fair enough.
And that's perfectly fine. But if you start squeezing my suppliers by saying, hey, you better not sell cheese to Bardwell anymore, or else I'm going to do such and so. You better not sell Bardwell any more beer, or else blah, blah, blah. Well, that's different. That's anti-competitive. And if you held a monopoly on the cheeseburger restaurant industry and tried to squeeze me out that way, well, at that point you have created antitrust questions.
So, and that's a good analogy, because from my point of view, and I imagine many people listening to this and on social media and whatnot, it almost seems like that's exactly what the PGA Tour is attempting to do right now. And I think that was the crux of what your article was about.
Yeah, and look, there are nuts and bolts in antitrust law in particular. Antitrust law is kind of a weird area of law. There are finer points in there that will be argued until people are blue in the face about it. But just looking at the broad strokes of it, look, this is nothing new. The PGA Tour has expected litigation over this since the very beginning. And I have to believe that is at least partially out of the recognition that this strategy against LIV was going to at least invite questions about whether they have run afoul of antitrust prohibitions. I think this, who the hell knows how this is going to go, but it certainly appears to be a serious case.
Another, I guess, interesting element of this particular case is the restraining order that was also filed by 3 players, Taylor Gooch and a couple others, for example, that previously qualified for the FedEx Cup playoffs that begin next week at the time of this recording, and they want to play again. So how does that wrinkle things?
Well, let's start first with the nomenclature. So when most people hear the term restraining order, they think of like maybe an abusive domestic abuse situation where a battered wife has to get a court order for her abusive husband to stay away, something like that. That's this, when people hear restraining order, that's what they think of. A temporary restraining order in the civil litigation context is not like that at all. All it means is that it temporarily restrains a party, usually the defendant, from engaging in behavior that the other party claims is violating its legal rights. So in this case, those 3 players have asked the judge for a short-term order, temporary, that the PGA Tour not prevent them from participating in the FedEx Cup playoffs. Now, this is not usually a step that occurs. I wouldn't call it rare by any means, but usually lawsuits do not involve this step. Usually the first few months of a lawsuit are pretty boring. But this is going to be a big deal right off the bat. There'll be a hearing on Tuesday on this motion. I assume there will be witnesses put on. Sometimes you see it, sometimes you don't, but this certainly seems like a fact-intensive case that would need evidence put on. And it'll look a lot like a little mini trial, at the end of which, at some point before Thursday, the judge will need to make a decision about whether the players are entitled to this short-term order, this temporary restraining order. Now, one of the things the judge will have to decide at the end of having heard all this evidence is whether those players have demonstrated that they are likely to win this lawsuit. And so whatever the judge rules, the side that wins is going to feel pretty good. Now, whatever the judge rules about that, it doesn't necessarily mean that's the way it's going to go at the end of the day. The judge could certainly go one way on this temporary restraining order, and then the case could go the other way at the end of the day. But anytime you file a motion for a TRO and you win on that motion, you walk away from that feeling pretty good about your chances in the case overall.
So you would know this a lot better than I, but I imagine there's always some form of strategy with the timing of things. And it struck me as interesting that the complaint was filed at this time after 3 LIV events and just before the FedEx Cup playoffs. Is there any strategy behind that?
It's not impossible. I would say probably the easiest way to suggest that it wasn't a coincidence is just that the complaint's 105 pages. A 105-page complaint does not write itself. It's difficult, especially with law firms of this caliber. There are going to be a lot of layers of review. It's possible it just took a long time to put together. And frequently, when you are seeking preliminary injunctive relief, either through a motion for a TRO or a motion for a preliminary injunction, which is just sort of a more long-term TRO. If you do that and you walk into the judge's courtroom and you say, "Oh, and by the way, we need you to do this right now," that's a pretty good way to piss the judge off. To say, "Well, why are you just showing up now? Why weren't you here last month?" And so my guess is, and these lawyers are unbelievably talented lawyers. They would know that. I doubt very much that they did this in an effort to try to put the judge over a barrel.
Fair enough. And the reason I bring it up is because I know there's already been some chatter about, the timing of this, and it's interfering with, some of the women's golf events that are going on and all that. So, but that makes complete sense. This is not a brief document.
No, I think it probably just, and these things always take longer than you think they're going to take. And by that I mean preparing a document like this, especially at this length. So I think the likeliest explanation is just that it took a long time to put together, and as soon as it was ready, they went to the courthouse.
Fair enough. So taking a step out of the actual document itself and more towards what people are chatting about, obviously the first thing that comes to mind is that originally the messaging that we all know was BS of wanting to spend more time with family and playing less golf. Now people are saying, they're trying to play more golf. And this also comes on the heels of the announcement from LIV that next year Asian Tour events will have to be played by a lot of these players, or at least strongly recommended. What sense do you make of all of this?
The Asian Tour aspect of it?
That, and the fact that now people, the 11 players want to play more golf now. It seems that way, at least.
Yeah. I don't necessarily see anything about that undermines the claims they've made. I mean, the claims at the end of the day are just that the PGA Tour is engaging in anti-competitive behavior against LIV. And honestly, I suppose you could make an argument that the fact that these players are going to have to play on an inferior tour like the Asian Tour just to have OWGR opportunities, I suppose you could argue that supports the argument that they're making. It supports the notion that the PGA Tour has blackballed them out of the major pro golf landscape to a degree that is anti-competitive.
Okay, that makes sense to me as well. And you had shared a text not too long ago in our group chat that we have that there are some questions that arise regarding how the PGA Tour could even respond to this, as well as how does this lessen the competitive nature of their tour. Some moves that are being insinuated by the plaintiffs in this instance, where, the PGA Tour is only doubling down on some of this behavior. I mean, maybe expand on that a little bit. Where does the PGA Tour stand on all this right now?
Well, I've talked about this with a couple of different people, and each time I've found myself using the phrase, I'll be interested to see what they have to say. And that sounds like the sort of thing you hear on sports talk radio all the time, right? Where somebody's just filling time and say, well, it'll be interesting to see what happens. But truly, I am very curious to know what the PGA Tour has to say about this, because it has been obvious to a lot of people for a long time that there was going to be litigation about this, that it was probably going to involve questions of antitrust violations, and that at least at first blush, those appear to be serious questions. And so what is the explanation here? There are allegations in this complaint that are just difficult to explain with any other explanation that they were anti-competitive. There's the story of Andy Ogletree, completely ineligible for any tour event or KFT event, asking for permission to go play in the LIV event and being told, drop dead, basically. Those are my words, not theirs. And he asked the question, what am I expected to do? Sit on my couch and not make money? It is difficult to come up with any explanation for why the tour would insist that he, in Andy's words, sit on his couch, other than that they were trying to keep a player away from LIV out of an anti-competitive motivation. And so I am truly interested to know, what is their explanation for this? Is there some other way of looking at this other than that you were just being anti-competitive? So I can't wait to hear what they have to say, because I've been wondering for months.
Yeah, I mean, framing it that way makes a ton of sense, and it's a matter of what the PGA Tour has been saying, even in the memo that they sent out to the current PGA Tour members, saying that, the LIV is trying to leverage something off of you, and this, that, and the other thing. And plus, on the other side of this, we now have PGA Tour players, Justin Thomas, Billy Horschel first, saying that, well, if they sue us, they're suing me. I mean, is there any credence to that?
I suppose you could, if you're Billy's CPA, suppose you might wring your hands over the possibility that if you play this thing out, years from now, and the tour is more financially strapped than it is now and can't offer big enough purses anymore, that that Billy won't be able to afford his top of the line Ralph Lauren trousers anymore. But I mean, the players do not have an equity stake in the PGA Tour. In the same way, like if I'm a shareholder in, say, Amazon, and Amazon gets sued, then theoretically I have a financial stake in that litigation. You could make the argument that, at least in my capacity as an Amazon shareholder, I'm being sued, but the players don't have an equity stake in that. I think it's more of just a narrative sort of thing than anything
Yeah, fair enough. And I wonder if it's a matter of Well, I know it's a matter of them continuing to drive this divide between it's us or them type mentality, which I think this was ultimately going to be the way, at least, and it will be for the foreseeable future. So you mentioned in your article, again, on lying4.com, you mentioned that not only is this complaint extremely compelling, but am I correct, and I don't want you to speculate by any means, but it seems like this is a very, things are leaning in the favor of LIV, at least right now.
I wouldn't go that far, but I would say this is a serious lawsuit. And if you're a billion-dollar enterprise like the PGA Tour, you don't like to be involved in serious litigation, especially when that litigation is against an existential threat. This is this is not great for the tour. And anytime you're in litigation, anything can happen. Especially if you're talking about litigation where a jury trial has been requested like this. Anything can happen. You really would rather that the future of your tour not be in the hands of people outside your tour. And so the fact that the tour now is in this position is in and of itself a huge pain in the neck, and and not, if you're the tour, is not good. Now, that doesn't necessarily mean the tour is going to lose. If you were setting odds on this thing, it doesn't mean that the tour would be the underdog, but it's not good.
Right. Forgive me for this. This is where my ignorance comes in. I mean, is this a matter where there's going to be a winner or a loser, or a loser, or is there any room for a settlement of some sort down the road?
There's a great line in a terrible movie, the second Matrix movie, The Matrix Reloaded, where the character called the Architect, who's sort of in charge of the Matrix, is threatening the star Keanu Reeves, Neo, with some outcome, and Neo points out that if he goes through with this, that it would basically destroy the Matrix. And the Architect's answer to that is something like, there are levels of survival that we are willing to accept. And so I think about that in the context of settlements a lot. Like, are there levels of survival here that you are willing to accept? The answer to that is almost always yes. There's almost always room for some sort of a compromise. And any time, my philosophy as a litigator is always, if you can settle the case, if there's any chance at all, settle it. Because the last thing you want is to turn this thing over to people whose decision-making is completely out of your control. If you're involved in a settlement, you're going to have to give up some stuff you don't want to give up, but at least you are in control of that. At least you get to say at the end of the day, yes or no. You turn it over to a judge or a jury, you have absolutely no control over what happens. And so if there's any way at all to settle it, you settle it. I have to believe there is some sort of arrangement that the tour could accept. Now, how good or how bad that is for the tour, honestly, this TRO hearing on Tuesday will probably say a lot about which side has more leverage over the other. Because if let's say you're the tour, let's say you go through this hearing on Tuesday and you win, and the judge declines to grant the temporary restraining order. Well, at that point, you feel great about the way this lawsuit has started. And the first time you have settlement negotiations with the other side, and they come at you with an offer that you don't like, you say, "Look, dude, we just went to a TRO hearing and won right out of the gate. I don't have to take a bad settlement offer from you. In fact, here's my settlement offer, and it involves you jumping off a bridge." So whoever wins this thing is going to have a lot of leverage in those negotiations right off the bat.
Do you foresee in any way, shape, or form, and this is pure speculation, I understand, but these two entities surviving at the same time? Is that where we end up in everything?
I have a hard time believing that at the end of all this, the PGA Tour shutters its doors. I also have a hard time believing that at the end of the day, the Saudis just walk away from this thing.
Right.
I think, put it this way, I think 10 years from now, there will be something called LIV Golf and there will be something called the PGA Tour. What those two entities look like probably turns a lot on what happens in this case. Are they two both still co-dominant figures in professional golf? Has one of them basically beaten the other? Remains to be seen. But I would be very surprised if 10 years from now, one of them has completely killed the other.
Yeah, I agree with you. And it'll be interesting because when I view this, and once again, folks, we're talking to Will Bardwell of lyingfor.com. Go out and read his excellent piece. And Here We Go is the title of it. I sometimes wonder if this is what, you think about all these mergers and these other elements of other professional sports, whether it be professional football, the two leagues combining, whether it be whatever else. I wonder if this is a turning point in professional athletics in any shape or form that might be the precedent for something moving forward. We won't know now, of course. Time will tell. But in the grand scheme of things, in your opinion, from a historic standpoint of sports, where does this rank?
Well, at least within the history of the tour, this is the greatest existential threat that the tour has ever faced. I think it's interesting that the tour is facing this for the first time. You mentioned the NFL and the AFL. But the NFL is not the only major sports circuit in America that has faced a major threat to its dominance. In fact, the NFL has done it a couple of times, right? There's been the AFL and the USFL. Right. But the NHL has had a couple of upstart rivals over the years. Of course, there was the ABA. Hell, you could even maybe point at the XFL, the first XFL, as a pain in the NFL's neck, at least.
Right.
It's kind of unusual that the PGA Tour has never had to deal with this, other than the World Golf Tour thing. It wasn't at the end of the day, was a very short-lived threat. And I have wondered whether the fact that the tour doesn't have this sort of thing baked into its DNA, whether that is contributing to what has appeared to me to be a pretty ham-handed response. The fact that they've never had to fight for their lives before. Is that contributing to what appears to be a pretty sloppy strategy on their part? I don't know.
Yeah. Time will tell for sure. I'm wondering also if this is just a matter of the DP World Tour and the PGA Tour combining and forming something like the World Golf Association or something of that nature, because certainly, if anything, we've learned that the PGA Tour cannot handle this by themselves. They don't have any way, in my opinion, of doing so financially, nor they don't know what they're doing, it seems like, at this point.
Well, there's also the possibility that I realize people are mad at each other right now, but sort of along the model that the Premier Golf League was proposing there in the end, is there a way for LIV and the PGA Tour to merge, where LIV sort of operates as the Champions League of pro golf, and the PGA Tour is sort of operating supplemental to that? I wouldn't want to describe it as underneath that, but is there a chance of that? I don't know. They may hate each other too much at this point to describe that. But again, when you start talking about, are there levels of survival you're willing to accept? If you're the tour, would you accept that over being relegated to basically being a minor league of professional golf?
Right.
Maybe you would.
Yeah, I think survival at this point is probably ideal for all sides, and it's just going to be a matter of, as you mentioned, how this trial goes, the hearing goes next week on August 9th, at least the time of this recording. So, well, sir, I'm sure we will be staying in touch as we do. And once again, go out to line4.com to read Will Bardwell's update on the ongoing litigation between LIV Golf and the PGA Tour. Will, thanks so much for hopping on this morning.